Commissioner Stephen Fisher against HMRC and HMRC against Anne Fisher.
Mr. Ewart, before you begin, I've got a bit of a shopping list. First of all, we're trying to understand how the revenues approach has actually worked in practice. So it would be very helpful for us if HMRC could produce a table showing what additional income tax they're seeking to collect from each of the taxpayers in each year under appeal arising from the profits of SJG.
Yep.
It would be helpful if also the proportion of the profits that is being attributed to each of the individuals could be indicated. That's the first matter.
Yep.
Obviously, some time will be needed to do that,
yes.
And the appellants will need to have an opportunity to check that they're happy with the figures that are being produced. But that would help us to understand what's going on here. The next matter is that in your submissions, it would be extremely helpful for us to understand, first of all, what transfer we're actually talking about in the authorities that you're relying on concerned with companies, whether we're talking about transfers of shareholdings or transfers of assets belonging to companies in which shareholdings are held. And it would also be helpful for us to understand the basis of the assessments to income tax. For example, in the present case, are the assessments under subsection 2 or subsection 3 of section 739? So maybe you're going to cover these things, but
yes.
I'm just wanting to make sure we don't leave these uncovered.
Yes. Okay.
Thank you.
If I fail to answer them, she'll remind me as I'm going through. But I
thank you.
The point. As regards the table, yes, we'll get it produced, but that will be, I imagine, after the hearing.
Yes. If you're able to.
I'm sure it can be agreed because I'm sure the figures are there.
Yes.
And somewhat.
Yes. There are. We do have in the bundle some of the assessments, but we're not sure that we're understanding the figures.
No. And some of the assessments were there because you may have seen that at earlier stages in the proceedings there were issues about the validity of some of the assessments for various technical reasons, which is probably why they were actually there.
Yes.
Yeah. Some of them have fallen. Some did fall because of that. Yeah. Some technical reasons, I think, before the special first tier tribunal. Yeah.
Yes.
But we can provide a table as to what's remaining and what we can perhaps indicate which ones fell out because of technical problems as well.
Yes, and as our concern is really to understand the revenues approach. If at the end of the day the appellants don't agree with what's being said, your comments will be helpful, but it's not going to be fatal. The point is to help us to understand the revenues thinking.
Yes, certainly.
I suspect there will be no difficulty in just identifying the amounts in the assessments.
Yeah.
I should perhaps remind you that this case has always been on the basis that a decision in principle was being sought and not finally agreed figures.
Yes, yes, we appreciate that. I mean, realistically, if that could be produced within, say, a couple of weeks,
Yeah.
that would be very helpful.
I'm sure that's possible.
So that we can get to work on this over over what's laughingly called vacation.
I can't think of anything better to do, but I'm biased on that. So I was, before I get back to Section 739, I was just going to cover the Majesty point and Mr. Justice Walton's judgments, which you have. I agree. My letter friend, I think, has identified some passages. I wasn't going to take you to them. What they are essentially Mr. Justice Walton, in strong language, railing against the unconstitutionality. And I think that's a reference to niceties. It's probably constitutional niceties that he's talking about. The unconstitutionality of the provision of the revenue's approach at that time, which was to deal with it by concession, essentially, or administrative. And he broadened that out, in fact, in one of the judgments to railing against extra statutory concessions in general, stating that there was no justification for them. Now, the law has moved forward on that. Obviously, there's been case law on extra statutory concessions.
Yeah, some of us were involved in some of that case.
Yes, and certainly it's been held that it is legitimate in certain circumstances to have extra statutory concessions. You may have noticed also Lord Edmund Davis in the House of Lords questioned whether extra statutory concessions were legitimate at all. So that's what it really is, and so that's what these passages are. They were in a sense obiter, because at that stage Sir Justice Walton recognised that he was bound by Congreve, and I think another case called Bambridge, not to look at the transferor, you might call them. And as I said, he found a number of imaginative ways of getting around that, which were all said not to be correct by the House of Lords in the end. But that's why you may have noticed the revenue were in fact the Appellant Majesty, because they had actually lost before Mr. Justice Walton, but not for the reasons that the House of Lords gave. So before I take you again to 739, I just thought I mentioned Benyon, and I thought I would just draw your attention to the passages that I was mentioning yesterday. Benyon is in. The first passage is on page 3135 in the bundle, authorities bundle, and this is about Consolidation Acts. And it's particularly the first paragraph under comment. Starting point in constraint consolidation is to approach it in the same way as any other act, without reference back to the provisions as replaced or judicial decisions on their meaning. Note, however, the discussion below about the application of this principle to case law. And that's footnoted Farrell and Alexander. The purpose is to gather together disparate provisions. The benefit would be significantly undermined if, in order to construe a Consolidation Act, it was routinely necessary to expend time, effort and expense investigating previous legislation and case law.
But I think the rule is, per Farrell and Alexander, that if there's uncertainty, significant uncertainty or ambiguity arising from looking at the legislation as it is now, then a subordinate presumption comes into play that there wasn't an intention to change the law, which means that you do have to look back to what the law was.
Exactly, and courts have routinely regarded themselves, lower courts, as being bound by decisions of higher courts on the interpretation of identical legislation in a previous consolidation. So, for instance, if there was a case in the House of Lords on a provision in the 1970 ICTA, when it was then reproduced verbatim in the 1988 ICTA, and a case arose at that time, certainly up till now, courts have always, the Court of Appeal, the High Court, would regard themselves as bound by the decision of the House of Lords on the interpretation of the same words in the same provision. That's because the tax legislation, the consolidation was a pure cut and paste, copying out exercise in the past. Obviously, we have the rewrite where it changed, but before the rewrites, tax legislation was always consolidated by simply copying it out from the previous version. So we've always regarded that as being the case. Now, you might say, strictly speaking, maybe that's not right, but that's certainly the way.
At some stage, it would be useful, certainly for me to get things clear in my mind, just to have a table of the derivation of section 739, because I don't have that clear in my mind at the moment, and at what point it was consolidated into consolidating legislation. So was the 1970 Act a consolidating Act? And were there consolidating acts before then?
Yes, the 1952 Income Tax Act was a consolidation.
Right.
I think that may have been the first one after there was a 1918 Act. And then,
at all events, would it be possible to add to my Lord's shopping list, just if we could have a table which sketched out the,
I think it's right to say that all the provisions...
Your wish is my command, my Lord. It's at the appendix to our case, because I hope exactly what is on your shopping list. It has the history of the legislation, tracing it through from 1936. It's the appendix to our case, and that follows through. We've given you all of the previous legislation. We also gave you the Hansard material, not that any point is being made on the Hansard material, but I hope that answers.
So when you say were consolidated, that means in a consolidation act?
Absolutely, yes.
Yes, thank you.
Sorry.
Yes, I think it's right to say that all of these legislative provisions are in the bundle as well.
They are, yes.
Yeah,
We've given you, as to say, all the legislation that's referred to in that appendix. I'm afraid sometimes the legislation appears in more than one version, but you can trace it all the way through if you're so minded to do so.
But it would be useful to know, this may or may not be in addition to the shopping list, which of the different pages in the bundle of the legislation are the ones that we should be, for example, setting out in the judgment, and the ones on which we have I realise that the years of assessment cover a period, but which are the ones we should be construing?
The provisions in force at the relevant times are the provisions, first of all, in tab, right at the beginning of the authorities bundles. Those are the provisions that were in force for the first 3 years. For the 4th year, I think it's right to say it was actually the 2007 rewrite that was in force. So those are the provisions in force at the relevant time. The relevant time being when...
Right, so when those all, for example, 1041 say superseded...
I'm sorry, I was going to turn to the legislation.
Oh, okay.
Can I just show you what I mean by that?
Yes.
Section 739, the version of it is the version on page 1039.
Yes.
Yeah, and we can see that was in force from 1997 until the 5th of April 2007. So that would cover, does it the entire period?
No, it covers the first 3. There's 1 year which is covered by the 2007
Act. Which goes into the 2007 Act.
Yes. Which is a
and I think in the tribunals and courts below, it was agreed that there was no substantive change, and so the whole argument proceeded by reference to this version of Section 739. Is that right?
That's right. And that's the position in this court, with one exception, which is the new point that has been raised about taxation, which wasn't raised in the courts below. There is something I have to show you in the 2007 Act about that. But apart from that, you're right, yes, we've always argued it on the basis of Section 739.
So where do we find the provision that applied for the 4th year?
I was going to come to that, if you don't mind later on.
Right, but for example, we've got in the bundle 2 versions of Section 740 and quite a few versions of 74.
Yes, there may have been some small amendments made. I don't think there's any difference in substance of any.
Right, and also 2 versions of 742.
There were a number of, what then happened was that the motive defence, and this comes into the rewrite, 741 is a motive defence, but in 2005, a new provision was introduced, which only applied to transactions after that date. And that's why you have, on page 1048, for instance, 741A. Now, that provision is not directly relevant to this appeal because none of the transactions that we're looking at, i.e. the transfers or associated operations, in relevant ones, took place after 5th December 2005. They all took place before it. And so the original version of 741 has continued in force. When we look at the rewrite, you will see that there are two provisions for the motive defence. One which applies to transactions before 5th December 2005 and one that applies to transactions after 5th December 2005. And I will come back to that, but because of that, what you're going to decide about taxation has a continuing relevance. It's not a historical, it's not a matter of pure history. It will still be relevant for income arising today in structures that were created before 2005 to determine the true meaning of what was Section 741. The purpose of introducing the new provision is to make the provisions more objective. I think the problem that was seen about the previous provision is that there was a subjective element to it, and that meant you looked in the mind of the taxpayers, or some of the taxpayers, or those who were planning it or controlling it, to decide what the purpose of the transaction was. Whereas the provisions in 741A are expressed in objective terms. So condition A, for instance, it would not be reasonable to draw the conclusion from all the circumstances of the case that the purpose of avoiding liability to tax was the purpose, etc. So it's intended to be one where the courts can take an objective view rather than having to decide what someone...
You'll still the focus is still on the subjective intention, but it's objectively assessed.
Objectively assessed, exactly. It's the purpose, but it's objectively assessed. Yeah. But anyway, sorry, my lady, so that's why we have these versions of 741. They were in force, but they're not relevant to this appeal. So it's all these provisions, insofar as you want to, in that part, that are relevant. And then, strictly speaking, the 2007 Act for 1 year, but subject to one point, we're not taking any. No one's saying there's any difference between the two. They deliberately reenacted it, although they rewrote it. They deliberately left the same difficulties that there were in 739 in the provision, so they didn't solve the problems, which was what was intended by the rewrite. It wasn't intended to. If there was a difficulty under the old legislation, they were supposed to keep it under the rewrite. Sorry, can I just go back to Benyon for a second? I think there was... The other passage I just wanted to draw attention to was on 3127, where an act makes textual amendments to an earlier act. The intention is usually to produce a text that may be construed as a whole in its revised form. So that is particularly relevant, we would say, in relation to...
I'm sorry, where are you?
Sorry, 3127.
Yes, where on the page?
That's headed up.
It's under the following principle should be borne in mind is A, little 1.
Ah, yes.
Where an act makes textual amendments to an earlier act, the intention is usually to produce a text that may be construed as a whole in its revised form. So one has to construe the legislation with in this case, we would say with subsection 1 capital A in it. It's maybe an obvious point, but I thought it was worth showing you what Benyon said. Can we then go to section 739?
And sorry, just on that, I think you told us yesterday that section 739(1)A was introduced to deal with the effects of the Willoughby case.
Yes.
You're going to explain that to us.
I'm going to come to that, yeah. So, we had reached section 7474B yesterday. The rest of subsection 1 is what used to be, originally was the preamble to some of the earlier acts.
I think that was right up till ICTA 1970. It was the 1988 Act that made this a substantive subsection.
Yes, I think
till then it was a preamble. It is hereby enacted.
Exactly.
And there was the enacting provision.
Yes.
I'd be interested to know what your understanding is of the thinking behind the switch from a preamble to a substantive section.
What was the thinking? Well, perhaps it was thought preamble was rather strange and old-fashioned. I'm not sure there's any significance in it because it still acts as a preamble in the sense that it states, we would say, it serves two purposes. One is to state the purpose of the provision, which is what it does, and the other is to define, if you like, some of the terms that are then used in subsection 2. Because when we come to subsection 2, we'll see, if we can just look at that now. So where, by virtue or in consequence of any such transfer, so first of all, you've got to say, what is such transfer? And such transfer is the transfer mentioned, or the kind of transfer mentioned in subsection 1. That is to say, transfers of assets, by virtue or in consequence of which, either alone or in conjunction with associated operations, income becomes payable to persons resident or domiciled outside the United Kingdom. So that's the kind of, that is the such transfer that's referred to. So where by virtue of consequence of that transfer, either alone or in conjunction with associated operations. So this is simply ensuring that you might make the transfer, but it might require further actions in order for it to become income payable to a non-resident, etc. Such an individual has, now that's the second term, such an individual, and we say that is a reference to an individual's ordinarily resident in the United Kingdom. There is some, possibly, some difference of opinion on this in some of the House of Lords decisions. I'm going to come to this. There is some suggestion that in fact such an individual is actually not just an individual ordinary resident, but an individual ordinary resident who is seeking to avoid income tax by a transfer. Now we would say that is simply not the correct construction of the provision. And it cannot be right for a number of reasons, which I'll come on to when we perhaps look at the motive defence. But there is absolutely no necessity for Section 739 to apply for the original transferor. I just pause there. I'm using transferor as a shorthand. I'm not suggesting that that's the statutory language, but I think it's convenient to use that. There's no requirement for the transferor to have any purpose of avoiding any tax, let alone income tax. And just to trail why that is because you test the motive defence not just against the transfer, but against all associated operations. Secondly, this may depend on your view of taxation, the motive defence, but it isn't a requirement, we would say, in any event, that the transferor should be seeking to avoid income tax. The transferor could be seeking to avoid another tax, inheritance tax.
Why do you say that?
Well, for the section to apply. What I'm saying, my Lord, is not an independent condition of the application of Section 739 that the transferor should be seeking to avoid income tax.
Well, but it might be said against you that subsection 1 is a scoping provision, and they have effect for the purpose of preventing the avoiding by individuals ... of liability for income tax.
Yes, that is the purpose of the section, not the purpose of the transferor. And that distinction is drawn in some of the cases. And to make that absolutely clear, my lord, subsection 1AB makes it clear that you cannot draw the conclusion from subsection 1, cannot be taken to imply that the provisions apply only if the avoiding of liability to income tax is the purpose or one of the purposes for which the transfer was effected. That is by the transferor. So you cannot draw that conclusion. The Parliament is making that absolutely clear. You cannot draw that conclusion from subsection 1.
Yes.
That the provision only applies in those circumstances. What subsection 1 is telling you is what the general purpose of the provision is. But it's not indicating a limitation on the application of that provision.
But is that also supported by the words in subsection 2, whether it would or would not have been chargeable to income tax apart from the provisions of this section?
That is the that's referring to the income of the non-resident.
Yes.
I mean, income of the non-resident might be charged to income tax without this provision. For instance, if it were UK source.
Yes, but here, if when this was all taking place in the UK with SJA, the fishers were not charged to income tax on the profits of SJA. They were only charged, presumably, to income tax on their salary or dividends or whatever.
Yes.
And SJA would be charged to corporation tax. The change is that when it moves to SJG, then regardless of what corporation tax SJG is paying and regardless of what income tax they're paying on any salary and dividends they still receive from the Gibraltar Company, the profits of the Gibraltar Company are treated as their income for income tax purposes.
I understand that, but that's...
Well, I'm asking whether I've understood. I'm sure you understand it. I'm just checking whether I've understood it correctly.
But the provision that you were pointing to in subsection 2, which says that income that is the income of the non-resident.
Yes.
Whether it would or would not have been chargeable to income tax apart from the provisions of this section, that's referring to the income of the non-resident. As I say, sometimes income of a non-resident might be chargeable to income tax in the UK. For instance, if it's UK source income, it's quite normal. It would still be charged to income tax, but that doesn't stop this provision applying, because it will be charged to income tax in the past, certainly at the basic rate. Yeah,
and there's a later provision that says that you don't tax it twice.
Oh no, credit would be given if income tax was paid by the non-resident, yes. But the point of those words is simply to make it clear that the fact that the income of the non-resident is subject to income tax in the UK does not take it outside this provision. The purpose is to top it up to the higher rates that the taxpayers will often be paying, rather than the basic rate, which is what the non-resident would be liable to. So, for instance, rental income in the UK from a UK property would be liable to UK tax, and it would probably be paid under deduction to a non-resident of UK basic rate income tax. But that would still be within 739 if the other conditions were satisfied. So that's what those words are. My submission, that's what those words are doing.
I think you say that such an individual is a reference to individuals ordinarily resident in the United Kingdom.
Yes.
But that seems to conflict with what Viscount Dilhorn said at page 1451, letters D to E.
Yes, I was going to come on to that. Yeah. Yes.
And also would conflict with the judgment of Lord Wilberforce.
Well, I'm not sure about that. I'm in my submission, if you carefully read what Lord Wilberforce says, he doesn't actually adopt that particular construction, I think quite rightly. He puts it on a wider, broader basis than that. it's Viscount Dillon who actually specifically says that, and we would say that's simply an incorrect construction of the provision. But even if it was right at the time, it can't be right now because of subsection 1AB.
1AA.
1AA as well. Because 1AA is making it clear that it's not a requirement that the individual be ordinary resident at the time of the transfer. What the reference to ordinary residence is ordinary residence at the time of the income arising. So such an individual, if we go back to subsection 2, by virtue and consequence of the transfer, I'll miss out those words, such an individual has, within the meaning of this section, power to enjoy, whether forthwith in the future, any income of a person resident or domiciled outside the UK, which, if it were the income of the individual, would be chargeable with income tax by deduction or otherwise. That income shall, whether it would not be chargeable to tax, be deemed to be his income. So what we're looking at this stage is the individual who's resident in the UK at the time the income arises, and that he has power to enjoy the income. And if those two things coexist, then he is chargeable under section 739. And I don't think there's any doubt about that. There's no doubt that these are two conditions of section 739 applying. But where subsection 1AA comes in is to overrule, if you like, the decision in Willoughby, which was to construe these provisions as meaning that the individual also had to be ordinary resident when he made the transfer. And I'll come on to that, but that was based...
Sorry, can I just check something?
Yeah.
The power to enjoy, is that in the present tax year? So you look to a past transfer, and then in any later tax year, you look to see whether there is a power to enjoy that income. And if that second condition is fulfilled, you then treat the income in that tax year as the income of the individual.
Yes. So if you cease to have power to enjoy, for instance, I think in this case, some of them sold their shares, so they would no longer have power to enjoy the income, then you cease to be taxed. So you're only taxed, and this may have some importance when we come to look at later issues. To be taxed under this provision, you have to have power to enjoy the income of the non-resident. So you have to be, in that sense, involved in the transaction. And you have to continue to have it. So if you were to give up whatever rights you had that gave you a power to enjoy, then you would no longer be taxed.
I would be interested at some point in knowing which of the possible ways that you have power to enjoy is relied on by HMRC in this case. So, when you come to it, that's fine. I don't want to take you out of your way.
Yes. I will. Well, there's no doubt that this would be the paradigm case of someone having power to enjoy.
Yes, I'd like to understand why.
So it's important that you have to have power to enjoy and be an ordinary resident in the UK at the time of the income arises to the non-resident. So can I just show you briefly what has been said about this provision in the earlier cases, so far as it's relevant? And we start with Congreve. That's at page 1241. And I'm going to look at a short passage from Lord Justice Cohen, which is at 1274. And it begins at the bottom of page 1274. I return to Mr. Tucker's main argument.
Mr. Tucker is for whom?
Mr. Tucker I think he was for the taxpayer in this case. Yeah, he was the taxpayer. I think at this stage, yes, it was Mr. Jenkins for the Crown at this stage. We do not think the words "by means of" connote activity by the individual concerned. According to the Shorter Oxford Dictionary, the primary meaning of the words is by the instrumentality of a person or thing, and they are fully satisfied if the avoidance of tax is effected through the instrumentality of the transfer by whosoever it is executed. A fortiori is this the case if we take the secondary meaning given in the dictionary in consequence of owing to, nor do we think the use of the phrase in the preamble in conjunction with the words avoiding compels us to interpolate something that is not there and read by means of transfers of assets as if it were by means of transfers of assets made by them. Moreover, we agree with the learned judge that the appellant's argument derives no support from the use of the word acquired in connection with the words by means of, since, as he points out, as used by lawyers, the word acquired has long covered transactions of a purely passive nature and means little more than receiving. Indeed, that is the second ordinary meaning given in the Shorter Oxford Dictionary. In addition, it would be contrary to the express object of the section if the words means and acquired were construed in the active sense which the appellants contend. It would put back on the revenue the burden of approving affirmatively that the benefits to the taxpayer resulted to him in fact through transfers and associated operations had all been brought about by his own activities. Whereas the section is, in our opinion, plainly and successfully drafted with the intent of casting the burden of disproving tax avoidance on the taxpayer.
But this reasoning is subsequently disapproved in Vesti.
Well, I'm not sure that this. I wouldn't agree that this construction of these particular words was disapproved.
All the words
the conclusion
by means of, or
the conclusion they came to was overruled by the House of Lords in Majesty.
yeah, I mean, these are all arguments for rejecting the contention that the taxpayer had to be the transferor.
Exactly, but they were based on a particular construction of some of the words in the provision, and those constructions weren't overruled in Majesty. What was overruled in Majesty was the broad way that the provision operated.
Yeah, well, if you like, Lord Wilberforce took a bit of a shortcut and
yes, exactly.
Said the outcome simply cannot be right.
Exactly.
Particularly for constitutional reasons.
Precisely, my lord. He said the outcome can't be right, and therefore you have to construe the legislation in a purposive way to avoid that outcome. That's right. Because of that problem. Can I just take you then briefly to, if you yourself?
I'm sorry, I'm not sure why you're focusing on our attention on this passage, given the change in Vesti on the big point. Why are you relying on this?
Well, for one important reason, my learned friend said, as almost a throwaway line, that the reason that they say you should interpret this as being the transferor is because of the phrase by means of, and they suggest that that is an important phrase in the provision, and I would adopt what Lord Justice Cohen said, but also more importantly what Lord Simmons said about that in the House of Lords, which is on page 1282.
But do you accept that the taxpayer has to be the transferor?
I accept that's what Vesti decided on that legislation.
Do you accept that Vesti is correct?
Well, I think what we've said in our case is all of the reasoning in Vesti is now undermined. That doesn't mean that that's not the correct answer. And I think that's a matter of construction of Section 739 as it stands. But I don't think you can rely on Vesti for that conclusion. That's what we say. You have to construe the legislation now as it stands at the present day and decide what is the relationship that is necessary, if any, for the section to apply to someone. That is fundamentally what we say the position must be.
So what's your answer to my Lord's question? Do you accept that the transferor has to be taxpayer?
Well, if you use the term transferor, and by meaning by that the person who made the direct transfer, then no, I wouldn't accept that. I don't think that's not what Vesti actually says. If you mean by that someone who is in some way associated with the transfer relevantly, for instance by procuring it or being involved in procuring it, then I would agree that is a construction of the legislation.
You're not asking us to depart from Vesti.
I'm not. As I explained in our case, Vesti is not a decision on this legislation. So the basis, we say that the basis of Vesti was the unconstitutionality. And we submit that no longer exists. We say the legislation is different now from what it was in 1970s when the Vesti.
The basic problem identified in Vesti was the absence of the necessary legislative machinery for there to be a constitutionally proper assessment, and the gap couldn't be filled by administrative discretion.
Exactly. And we say that problem has been solved since... Is
that by Section 744?
By Section
is that
744,
what you're saying?
Yes. That provides the machinery, the statutory machinery, and the ability to appeal to the...
It deals with the apportionment question, but you may have to explain to us how you deal with the issues about decision-making arising from the fact that we're dealing with shareholdings and decision-making by companies. You know, the issues we discussed yesterday about what you do if a director decides to spend the afternoon at the golf course when a critical decision is taken. That kind of...
Yes, but that issue, my lord, exists even if you accept Vesti as being wholly applicable, because as we shall see, Vesti itself, well, first of all, it wasn't a case about that, but even then, it envisaged that it was wider than the person who actually made the transfer.
Well, maybe,
yes, yeah, envisage that, yes, exactly. So the same issues would arise even if you accept Vesti in its full glory as applying to this legislation, even though the legislation is different and doesn't contain the major problem that was identified in Vesti. So
wasn't the first ratio...
I don't think Vesti is going to give you the answer.
Wasn't the first ratio of Vesti, according to Lord Wilberforce, a linguistic construction of the section?
He said that, but it's very difficult to identify exactly what the linguistic construction is. I'm going to come to Vesti and look at it.
I think Lord Nolan said it again in Willoughby.
Yes, what Lord Nolan picked up, though, was not Lord Wilberforce.
You'll come to that.
He picked up what Lord Dilhorn said, Viscount Dilhorn said, I think, not what Lord Wilberforce said. Because that's where Viscount Dillon explicitly made the point, I think as Lord Stephen pointed out, explicitly made the point that such an individual was a reference to not just ordinary resident, but someone who was seeking to avoid income tax, etc. And that's what I think Lord Nolan picked up in Willoughby in his reasoning in justifying the decision about ordinary residents. And of course, the problem then is that is what was reversed by subsection 1 capital A. All of that reasoning was reversed by subsection 1 capital A and B. That was the intention of it. It was introduced to do that. And it operated retroactively to some extent, as we shall see. Because although it didn't apply to income that arose after the 1996 date, it applied to transactions that had occurred earlier.
Just going back to the discussion on Farrell and Alexander, if we conclude that linguistically Section 739 is not clear, does that not take us back to Vesti? And Vesti was a decision on the interpretation of Section 739. It's true that part of the supportive reasoning involved difficulties of apportionment and so on, but ultimately it was a decision on the meaning of Section 739 itself. So if that were our view, doesn't it take us back to Vesti, which is a binding authority on the meaning of what is now Section 739?
Well, except that the problem you then have is that the other part of the reasoning, the linguistic part, has now been overruled by subsection 1A.
Well, we'll have to put two together because
That's exactly what
subsection 1 has been, section 1 wasn't repealed.
it wasn't repealed, but what Parliament said was you have to interpret it in a particular way.
Oh.
And that's what subsection 1A.
But that's
I'll come on to
what
that.
subsection. All right, you're going to come to this.
I'm going to
Just,
come to
just
that,
since
yeah.
you've made the point, I thought you told us that subsection 1A was to reverse Willoughby, not Vesty.
Yes, but Willoughby was based
So
on...
Parliament perfectly happy, seemingly, with Vesty.
It wasn't... I think what it did was reverse the part of the reasoning in Vesty, which was then applied in Willoughby, about the linguistic.
But
It wasn't intended to reverse it in any general sense. It wasn't reversing Vesty.
Section 1A doesn't deal with the concept of the taxpayer having to be the transferor.
Yeah, I thought it was section 740 that reversed Vesty insofar as Parliament wanted to reverse it by saying,
No,
all right,
yes.
739 is limited to transferors, however broadly or narrowly you define that. But where you have a non-transferor, then 740 means that they're taxed but only on benefits they actually receive.
Yes. That wasn't the intention to reverse it. That was replacing... that was something that was brought in to deal with a lacuna that was left after Vesty.
Yes.
Yep. That's right. Yes. No, absolutely right. So can we then... I was going to take you to Vesty. Sorry, before I do that, can I just draw attention to what Lord Simmons said, because he does deal with what's meant by my means of, etc., in the passage on 1282, which begins my Lord's question. So if I can just draw that attention to that, which goes on to 1283. My point was simply no one invested said anything about by means of that part of the subsection. Cast any doubt on what was said about it here. Can I then take you to Vesty, which is the part I want to start with is on page 1427. And it is the beginning of the argument of Mr. Potter for the taxpayers. And it's just the context in which this whole case was being decided. I think, as Lady Rose indicated yesterday, and we can see from, I'll show you a piece in the judgment, but it wasn't an issue in this case, what the scope of the transferor was. But it's quite clear that the starting point that everybody had, including even the Taxpayers' Council, was that it wasn't just someone who had directly transferred property. He even extends it to someone having power to stop it, allowed the transfer to take place. You can imagine circumstances, particularly in tax avoidance arrangements, where someone had a veto or something and didn't exercise it and allowed a transfer to take place. That was a possible situation.
Sorry, where do they say that?
This is after Mr. Potter, Holler, Pierce, Alsa, Wilson. Section 412 applies only to the transferor, i.e. the person who made or engineered or having power to stop it allowed the transfer. This is the construction of the language of section 412, the most probable meaning. If so, the jigsaw puzzle fits and there is no room for discretion. So So that was the basis of the argument. Now, it wasn't an issue.
He was saying that these taxpayers didn't come in even that wide definition of transferor.
Which in this case, they
Yes.
didn't. No, they didn't at all, because if you look at page 1434, you will see, just above letter C, it was a settlement made by the second Baron Majesty and his uncle, Sir Edmund Hoyle. Interestingly, you will note it was a joint settlement, and this is another point we'll come back to. These persons were the heads of two families. The respondents transferred no assets, had no hand in the settlement. They, together with a number of persons, are potential beneficiaries. So it was common ground that they had absolutely nothing to do with the transfer whatsoever. So it simply wasn't an issue in this case.
Then I'm not sure that you get very much assistance from the way in which the argument for the taxpayer was framed in that case, because in effect they seem to be saying, however wide
Exactly.
you take the notion of transferor, these people were outside. Whereas you seemed to be seeking to rely on it positively, or have I misunderstood that it's somehow it's always been accepted in the tax?
Well, it was certainly argued on the basis that it could be much wider than someone who simply made a direct transfer, and that's reflected in what the House of Lords say about it.
All right.
I agree in passing in this case, because it wasn't an issue in the case at all. But nobody has limited it to the direct to transferors in the strict sense of someone who actually directly transfers.
Whether council would have taken such a generous ambit if a point had been live, as it is in this case,
yes.
Who knows?
Yes, but he needn't have said this at all. He could simply have said it only applies to transferors and carried on. But and there's no reason why that.
It's not an unknown technique of advocates to say, however wide you take it,
exactly, yeah.
I'm not caught.
No,
that seems to have been the thrust.
Except that all I'm drawing attention to for is to show that was the basis on which everyone was proceeding in this case. So it's not correct to read the word transferor when it's used, which is what I would suggest the appellants have been doing in some respects, taking the word transferor where it's mentioned by someone in this case or another case and saying, aha, what we're doing is looking for the transferor. As if that were a statutory term. It's not a statutory term. It's simply expressing a concept, which is someone who is sufficiently involved in the transfer to be within the charge to tax.
Well, it's either doing that or it could be restricted to the transferor, in this case the company.
It could be restricted, yes. Well, it's not, because they haven't done that in Majesty, put it that way. It wasn't an issue, but they didn't restrict it in Majesty in that way. In fact, they suggested in Majesty that the alternative ground in Congreve was perfectly okay. The alternative ground being the procuring ground. If you remember, there were two grounds of decision in Congreve. One was you don't have to be the transferor, but alternatively, if you do, it's enough that you procure the transfer, which is what happened in Congreve. So it was accepted in Majesty. No one cast any doubt on that decision. They accepted that was a justification for the decision. What they were saying was that the primary ratio, that there didn't have to be any transferor, or you didn't have to be a transferor in any sense, was wrong.
And Congreve, I mean, if you were talking about procuring in the context of Congreve, was that just from recollection, was that to do with a controlling shareholder?
In Congreve it was, yes. Yep, that's right. And that's the point that Mr. Justice Walton made in Pratt, which we'll look at. But Pratt was a case which also, the facts occurred before Section 744 was introduced. They were going back to the 1970s. And Mr. Justice Walton said, okay, I accept a single person can be a transferor by procuring a company to make a transfer, relying on Congreve. But he said you can't have multiple transferors for the same reason as Majesty, because there was no provision for apportioning between them at that time.
Yes. So as far as Congress is concerned, whether or not, I can't remember whether it was a daughter, I think, whether or not she was a director, but by virtue of having a controlling shareholding, one could proceed on the basis that the transfer wouldn't have happened without her
Yes.
Wanting it to happen.
And as regards the director shareholder thing, I think it's a little more complicated than simply saying, well, the directors manage the company and decide to make the transfer. Because, of course, the shareholders, if they have a majority, either on their own or between them, can remove the directors.
Yes.
So they have considerable influence in what decisions are made by the directors. And it would be wholly unrealistic, using the words of my other friend, to say that either singly or in concert, shareholders who controlled the company were not procuring a transfer, particularly in the context of a transfer of most of the company's assets in this case.
Well, you say particularly, but we have to work out what the principle is. So is your case then that because the shareholders, however many there are of them, in general meeting, can remove the board of directors, anything that the directors decide to do in accordance with the delegated powers they have to manage the business of the company, anything they decide to do to transfer an asset, however much that is, or big that is, to another jurisdiction, that is enough to make that power to remove the directors is enough to make all the shareholders transferors of that asset.
I wouldn't go that far. I wouldn't go that far as a matter of law. I would say it is to some extent a fact-sensitive question as to whether, in the particular case, they were procuring or whatever it was, engineering the transfer. It may depend on the facts. If it was a small or unimportant asset, for instance, the directors decided for administrative reasons to transfer, then you wouldn't necessarily say the shareholders were involved in that. If it is all of the assets of the company, for instance, to take an example.
Yes, but there's a big spectrum between those.
And there'll be a spectrum between them, yes. Yeah. And
what do you look for to decide which side of the line you're on?
Well, you'd probably look at what actually happened, wouldn't you?
No, but what's the legal measure that you're applying to the facts?
Yeah.
The legal measure is whether they were, the trouble with these provisions, the submission I was going to make later is, you cannot, it isn't appropriate to have an entirely bright line, dividing line in a section like 739. The problem with having that is that as soon as you say, well, they've got to be this or that, then you find that people find their way around it quite easily. And it's deliberately been left wide. That there isn't any direct statutory indication in section 739.
Well, we have to be careful not to go back to the problem that there was in Majesty, of administrative discretion filling the gap. And people have to be taxed according to law.
I'm not suggesting that it would be a matter of discretion. In the end, it would be a matter for the courts to decide, for the tribunals, not for the revenue to decide.
But the courts have to apply legal principles. So
of course. Yeah.
Well, you've helped us with one. I noted you as saying that the shareholders have to control the company singly or in concert. So that's one legal principle as to the necessary degree of control. So they have to be acting. Either you have a single individual who controls the company,
yeah,
or a number of shareholders have to be acting in concert so as to control the company. And then the second point is the one that my lady raised, as to what do they actually have? What does their involvement have to be in the particular decision to transfer an asset?
Yes, and we're talking, of course, here only in the context, applying this legislation in the context of companies. Of course, there are multiple other contexts in which it would have to be applied. So this is a specific application, if you like, of Section 739 to a situation where the transfer is being made legally in form, anyway, by the company.
But what are you looking just for the powers that they have under the Articles of Association?
Yeah.
Or are you looking to what actually happened as regards this, so that if the shareholders have a power of veto under the Articles of Association, but actually the matter was never put to them at a general meeting, or they never voted on it, then they're in the clear? Or does the fact that they can call for a general meeting and then vote, is that enough to make them controlling?
But can I explore it this way? Supposing you're in a situation, if you're imagining a situation where the shareholders genuinely didn't know about the transaction taking place, so it was done by the directors without their knowledge entirely, it's a rather unrealistic situation, but if that were the case, then I can see that one might say, well, they weren't involved, they can't be said to be transferors. But that is an unlikely situation. I think it's more the fact that they are factually involved in the transfer, in procuring it, approving it, agreeing with it. They might procure it in the sense that they might ask advisors, what should we be doing? And the advisors might say, well, it'd be a good idea to transfer to this company.
So even if they don't have a controlling shareholding, if they asked asked an advisor...
No, if they would have to be together with others and procuring it. It wouldn't be enough. I mean, I think what again you're suggesting is that the unrealistic situation that only a minority shareholder knew about it and the majority shareholders didn't know anything about it. We've got to think about these things in a realistic sense, how it would apply in the real world.
And so the shareholders have to either control the company or singly, that's a single shareholder controlling the company, or the shareholders have to act in concert.
And I would submit there's no doubt about the first of these, and I think that the taxpayers pretty much accept that if it's a single shareholder who controls the company, then he will be regarded as the transferor in reality. The debate we're having is about whether that extends where there are, say, 2 shareholders who together control the company, or 3 shareholders, for instance. And in order to succeed in this appeal, we would submit the taxpayer has to show there's a matter of law that is impossible.
Well, isn't the burden on the revenue to establish that for them to establish that it was a transferor who made the transfer, that they were acting in concert?
The general position in tax appeals is that the revenue make an assessment. The burden is then on the taxpayer to displace the assessment throughout. Now, obviously, as with all litigation, the evidential burden might shift depending on what evidence the taxpayers produce. But the burden is initially on the taxpayer for obvious reasons. The taxpayer is the person who has all the information. So you can't...
Well, we're not talking about that.
That's the burden of proof I'm talking about.
Yeah, no. Well, I think what we're trying to explore is how can this work? Is there a clear way it can work? Because if the answer to that turns out to be no, then that's a pointer that that's not what the legislation should mean. It's not how it's construed. Now, when you say shareholders are acting in concert, that term, acting in concert, has a technical meaning in some circumstances, and I'm not sure whether you're meaning...
I'm not using it technically.
No. So how are you meaning it? That they all happen to vote in one direction?
No. Well, again, I think... With respect, these are rather unrealistic questions. If you're suggesting that they all independently vote without reference to each other, if that did happen, then that would be a very strange case, but we have to deal with it.
But forgive me, that wouldn't be a strange case. You might have dissension amongst the shareholder body as to what should be done.
There might be dissension.
And so you might have 3 shareholders, 2 vote in favour of something happening, 1 votes against.
Yes. I didn't think that was what my lady was talking about. I thought you were talking about a situation where they all were acting independently and weren't sort of talking to each other or
No, I'm not. I'm just trying to find out whether, when you say that that a number of minority shareholders, if they act together, you use the phrase in concert, but I think you're now stepping back from that, if that has a technical term. If they act together, that is enough for them to be all transferors when they vote together for the company or the directors to transfer an asset of the company to a person overseas. So I'm just trying to work out, is it simply the fact that they all vote for that, or enough of them vote for that, that makes them transferors? Or do you have to look behind the way they voted at all? Or is it enough that they just, enough of them vote for it to happen, for them to be transferors?
Yes, they wouldn't necessarily have to vote, because again, if you put that requirement in, then of course people would just not vote. But
yes, so what do they have to do then?
They have to be acting together and not in concert, if that's a particular one, acting together in order to, in the context of a company, to procure the company to make the transfer.
But what does it mean to say they're acting together?
It means they've got a common purpose, they're agreed between them that this will happen, either expressly agreed or as in the case of Anne or someone like that they have said, well, I'll agree with whatever.
Well, then you are using in concert in the technical sense, because you're saying that there does have to be some pre-agreement between them that they will all vote in a certain way, or enough of them will vote in a certain way. They might say, all right, well, you don't vote and you can have the tax break, but we will vote and take the
It can't depend on whether someone actually votes or not. That wouldn't make any sense. Well, they might not, of course, they might not actually have to vote at all. All they have to do is to allow the directors to make the transfer. I mean, it may not be necessary for the shareholders actually to vote in cases, because there may not be any requirement for them to vote. But if they stand back and let just as with one, let's say 100% shareholder in a company.
Well, no, that's a straightforward case. Let's not take that case.
But
what we're looking at is whether it's actually a principle that you can apply, because that case, that 100% shareholder doesn't work for the revenue in this case, so that's no point.
It doesn't, but
so what is it that you need to show?
The same problems would arise with it, because the 100% shareholder might not vote for anything. He might simply allow the transaction to take place, knowing it's taking place.
We need a principle that could be applied, for example, to a PLC with vast numbers of shareholders, which decides to transfer assets overseas, and the result is those set out in.
Well, I was going to come on to that later on, but and suggest that there are a lot of reasons why that would not be a problem. What you're envisaging would be a situation where the PLC, with the hundreds of thousands of shareholders, set up another company with all those shareholders having shares in it and transfer the assets to it. Now, in reality, that never happens. For obvious practical reasons, nobody is going to do that because they'd have to issue shares to thousands of individual shareholders. What they're going to do in all situations is form subsidiaries in the group and transfer the assets to subsidiaries.
Assume for a moment they do that.
If they do that in that weird situation, well, you have to ask why they've done it, I guess. You'd have to ask why they've done it, and if they do it, and there is...
Would all the shareholders be caught?
If they continue to have shares in the non-resident company, they could be caught, yes, possible. I'm not ruling it out, I'm just saying that it's a very unlikely scenario.
On your case, I can't see why they wouldn't be caught.
If they were involved in the...
Well, you say that passively not voting at all would...
Deliberately. I didn't mean passively simply because you didn't know. I meant deliberately not voting because you know that it's going to pass even though you don't vote. Could obviously be enough, because that would be the same with a single shareholder. you wouldn't have to vote for it.
Just say there are 100,000 shareholders. How, I mean, if just there might be a vote at an EGM, I suppose. Do the revenue then need to obtain the records of how every shareholder voted in order to decide whether to assess them to tax?
If this particular extraordinary transaction did take place, well, it is a highly hypothetical transaction. I mean, the problem with this line of reasoning is that
the rule must be the same whether you've got 10 shareholders or 1,000.
If they're involved in it, they could be within it, but it's just not going to happen. I mean and remember, the purpose of the legislation is actually to discourage people from doing this kind of thing, transferring assets abroad. That's the whole point of the legislation. That's why it's there. So if it has the effect of discouraging them from doing what you're suggesting, then it will be serving its purpose. But I'm not clear that you're going to get an answer to the practical problems that will arise in real situations by postulating something that's completely unrealistic.
What is the relevance, as far as HMRC is concerned, of the fact that the Fishers were the directors of the company as well as the shareholders? If this company had been managed by different directors who weren't the Fishers, what would have been the position?
It might still have applied. It just makes it clearer factually that what is happening.
Why does it make it clearer factually?
Because you can see that the directors are making the decision as part of the procurement by the shareholders when there is congruence between them. If the directors were other persons, the argument would still be there. The point would still be there because the Fishers might have said, "Look, we want to transfer our assets abroad. Talk to the directors about it." The directors said, "Okay, we'll agree to do it." They would still be procuring the transfer, just as. I'm sorry to go back to the single shareholder case, but single shareholder, he might have different directors of the company. His way of procuring it would be to say to the directors, I'd like us to make a transfer of those assets. And the directors don't, then presumably he'll remove them and put someone else in who will.
So the significance
the same point arises with the...
it's purely evidential.
Yes, exactly, yes.
And the directors can't themselves be transferors because they don't have the power to enjoy the...
Unless they're shareholders who will have the shares. Yes, they wouldn't have power to enjoy the income of the non-residents, so they wouldn't be within the charge at all. We're only talking about people who then subsequently get, in the context of a company like this, get shares in the non-resident company. We're assuming that takes place, which is why I say it's a very unrealistic example in relation to large companies, because they simply wouldn't do that. They would have all sorts of other tax problems if they did, because the reason that they do it within the group is because there are a lot of exemptions into group transfers. Those exemptions don't apply if you transfer it to a company which is owned by the same shareholders. You would then have to go into reconstruction relief, and you'd probably fail that because there's a tax avoidance test in that as well. So they no doubt end up paying corporation tax on the transfer. It just wouldn't make any sense for a company to do that. And we're also assuming, remember, my lord, that the main purpose of this is to avoid UK tax. The main purpose. In other words, this is not being done by this notional PLC for any commercial reasons. It's being done in order to avoid tax.
Well, no, it can be a bona fide commercial transaction.
It could be a bona fide commercial transaction, but all that means is it's on commercial terms. So the PLC could sell the shares, the assets, to the other the offshore company for full consideration. That would be a bona fide commercial transaction, as the first tier tribunal held here. But it would then, to fail the motive test, you're assuming that the main purpose, that is the only main purpose of this transaction, was to avoid UK tax. So it's for a number of reasons, it's a very unrealistic example.
I think we'd benefit if you were able to give us any clearer guidance as to in what circumstances a number of shareholders can constitute a transferor. You started off by saying that that would be the case if they acted in concert, and then you said, I think you acceded to a different way of putting it, if they act together.
I understood those to be the same, but I'm
right, meant to be the same.
Corrected.
I wanted to just be, we need to tease this out a bit, because whatever we say about this, if we accept your submission, is going to be examined very closely in future and relied on by people. So we need to be quite clear about it. Are you meaning that the individuals have to have reached an agreement on the matter?
I think that would inevitably be an element in this.
So the fact that their views might independently, they might have independent views which were which coincided, that wouldn't be enough because they hadn't actually entered into any agreement.
Yes. I think this goes back to the example of they all voted independently without discussing it with each other.
Yes. The coincident views, not enough, must have entered into an agreement.
And I think that would be necessary. And it all comes back to what my learned friend said. The way he put it was who in reality is the transferor. Now, of course, he was limiting that to a single transferor. And of course, we do have a finding of fact in this case that in reality they were the transferors. So in order to displace that, you have to say that's wrong in law.
Yeah. And to cater for
the wrong approach.
To cater for the case like that of a taxpayer Anne in the present case, I'm presuming that you would treat an individual who made it clear that she would acquiesce in the views taken by others, the action taken by others, as amounting to agreement.
Yes, we would say it can't matter that you say that you say to other people, I'll go along with whoever you. Yes,
effectively, if you give them a mandate, then you are taken to agree with what they then do in the exercise of the mandate.
Exactly, yes.
Okay.
You now seem to be rowing back from a position which I thought you were taking before, that the mere power of the shareholders to remove the directors is enough to make the shareholders the transferors of any asset which the directors decide to transfer.
What I was pointing out was that is why shareholders can procure a transfer of assets by a company. They cannot directly effect it themselves. They cannot vote for it because they don't have the management. But they can procure it because they have the power to remove the directors.
So that's why the directors will do what they ask. In reality, they can procure it. I'm sorry. That's why that may be why the directors decide to do what they ask, although directors, of course, have their own duties to...
Yeah. Well, they might, or they might, if they really object to it, they resign and someone else is appointed. Of course, it's much easier in a case where there is congruence, the same directors who have the plan are also the directors, because we don't have to even go into that issue of indirect influence.
So on your theory of how it works, if the shareholders and the directors are different, would it work in this way, that if the shareholders become aware of a proposal by the directors to make a transfer, and the shareholders then actively speak to each other as shareholders and say, well, are we happy for that to go forward? And they say, yes, we're happy, so we'll do nothing. That would satisfy your definition of in concert.
Yes.
Is that right?
Yes.
And the stronger case would be if the directors aren't proposing to do anything at the moment, but the shareholders get together and say, actually, we'd like to sell an asset, therefore we would like you, the directors, to think about doing that.
Yeah.
That would be enough as well.
Yes.
You still do seem to be moving away from the submission of the shareholders in Majesty, which was sort of where we started at page 1427, about the simple non-exercise of a veto power. Because, I mean, there may be situations where someone in practice might have a veto power if they decided to intervene, but they just aren't sufficiently interested, or just let matters proceed forward. How would your concert theory work?
Well, I think what I'm only guessing here, but I think possibly what Charles Potter was thinking of there is a situation where, for instance, there are provisions in a trust which provides that transfers can be made, but the individual has a power to prevent it, and that by not exercising the power and in fact allowing the transfer to take place, they might be regarded as a transferor. I think it's that kind of situation he's thinking about. I mean, all of this is in the context of plans to avoid tax. Remember, we're not talking about commercial transactions being carried out by companies for commercial reasons. We're talking about transactions being carried out planned to
well, the commercial reason in this case was a genuine sale of assets for which money was paid. There was also a genuine commercial reason: our business is going to go bust. And
that was why. Well, that's moving on to a different point about the motive.
I mean, to say that everything is about avoidance of tax is to underestimate what was going on in this case.
Well, can I 2 points? One, the sale was on normal commercial terms, as was held, and they got a valuation and they ensured, even though the two companies were connected, they ensured that it was the right price. That's true, but that wasn't the purpose of the transaction. The purpose of the transaction was not to get £500,000 or whatever is into SGA. Nobody suggested that. I will come on to the motive defence. But I do think there is a serious problem if your lodgers were to say it can be a purpose of a transaction where you are avoiding tax, a knock-on, if you like, effect or motive to, for instance, save the business or improve the business or some commercial purpose.
I think that's an argument that you'll be coming to later.
I'll be coming to it later, but I do think that's a very dangerous line to go down, because it would emasculate many anti-avoidance provisions in the tax code.
Insofar as you say, well, this is all fine, you can have lots and lots of transferors because it's still got to be for a tax avoidance purpose. But I think you've previously emphasised that it doesn't matter whether a particular transferor has that motive. What matters is for the transfer to be effective for that purpose.
Exactly.
And that's why you say Anne is caught, even though she doesn't have that motive. So the tax avoidance purpose of the transaction doesn't entirely obviate the need to be careful as to who is the actual transferor in any particular case.
Yes, I wasn't suggesting that you should be cavalier about it because of that, but I think, but what I was pointing out, you have to understand that's the context in which we're asking these questions. You wouldn't be asking a question if someone was a transferor in a wholly, if you like, innocent transaction. You're only asking it in the context of transactions where, at least on the face of it, it appears to be tax avoidance. And it is intended, as I think Mr. Justice Hoffman said, to be a broad spectrum anti-avoidance provision. It's not intended to be construed technically. The problem is that if you construe it technically and place a bright line restriction on it, for instance, if you say there has to be a single transferor, then that just opens up the whole provision. Everyone can easily avoid it by simply having multiple transferors. It would make the provision virtually otiose as an anti-avoidance provision. So you've got to bear that in mind. And given that there's nothing in the legislation, there's nothing in Section 739 that expressly limits it, what you're having to do is interpret Section 739, understand what limitation you're going to impose on it. And that limitation, I would suggest, would have to be something, if there is to be one, of broad nature. I do submit, though, that the focus of Section 739 is on the individuals who have power to enjoy. That's what the section talks about. It doesn't talk about transferors. I'm not suggesting that means necessarily that there doesn't have to be a transferor, but it doesn't mention transferors. So you do have to appreciate that the focus of Section 739 is on, because that's in a sense where the avoidance is. It's the fact that the individual, that the assets have been transferred to a non-resident, but the individual has retained or has acquired power to enjoy the income of that non-resident.
That term is very broadly defined in Section 740.
It is broadly defined, yes. It's intended to catch all sorts of possible situations in which you might be able to benefit. I was dealing with Majesty. I'm not sure how far we need to look at it. I was going to take you to various passages, and you've obviously read most of them already. Can I just take you to what Lord Wilberforce said about the interpretation of the provision? That's on page 1442 at the bottom, where he says there are undoubtedly two possible interpretations of Section 412, particularly having regard to the preamble. The first is to regard it as having a limited effect to be directed against persons who transfer assets abroad, who by means of such transfers avoid tax, and who yet manage when resident in the United Kingdom to obtain or be in a position to obtain benefits from these assets. For myself, I regard this as being the natural meaning of the section. This avoids all the difficulties discussed above. And then he does say no difficulty arises from cases of multiple transferors. And I have to agree it's rather obscure as to what he meant by that. Certainly there was no argument, as far as I'm aware, in the case about multiple transferors. Although the transferors in the case were actually multiple, I think, because it was a joint settlement. Yeah. But as I understand it, they didn't have power to enjoy the income, so they were not within the provision. Now, this I would suggest is not. Lord Wilberforce here is not actually getting down to the nitty-gritty and saying we've got to construe such an individual as meaning whatever in the provision. He seems to be taking a broader view of the interpretation of the provision, that's what it's directed against, and that therefore, as a result of that, you ought to interpret it as only applying to transferors. I mean, his conclusion was, in the end, the section, this is on page 1446, the section interpreted as applying only where the person sought to be charged made or maybe was associated with the transfer. So that's what he concludes in the end.
Yeah, but I mean, on 1442, bottom over to the top of 1443, he's positively saying that he regards the first of the interpretations as being the natural meaning of this section.
Yes.
And that's just Lord Wilberforce looking at the words used, saying I read these words as meaning this.
Yes, but what is he? Well, what words is he meaning? If you look at what he says, so regardless of limited effect, to be directed against persons who transfer assets abroad. Okay, well, he's whatever that means, and then he goes on to qualify that at the end. Who, by means of such transfers, avoid tax. Now, he, as opposed to Lord Viscount Dillon, doesn't limit this to income tax. I would say he's probably quite rightly thinking about the motive defence and saying that they have to, by means of that, avoid tax. It's slightly inaccurate language because there doesn't have to be any avoidance of tax. It's the purpose to avoid tax that's important. And indeed, one of the issues in this case, which was decided at earlier stages, was whether there had to be actual avoidance of tax, and it was decided by all the courts, up to the Court of Appeal, that there didn't have to be actual avoidance of tax. So, literally speaking, what he says there is not literally correct. I think it's they don't have to, by means of the transfers, avoid tax. But I think possibly what he's thinking of there, the thought is the motive defence and the fact that you have to have a purpose of avoiding tax.
Well, I mean, the preamble, now subsection 1, makes it clear that the purpose of the provision is to prevent the avoiding of liability to income tax.
Yes, that's the purpose of the provision. Yeah. It doesn't follow from that.
Charge. It's why the charge is there.
It's why the charge is there.
And the Parliament is telling us expressly that it's why the charge is there. So just to give you notice, I'm not at the moment persuaded that Sassoon is correctly decided, and that's something that I do wish you to address during the hearing.
I will, undoubtedly.
Yeah, I mean, as you say, 1A makes it clear that avoidance need not be one of the purposes of the transfer.
Yes.
But the purpose of the provision is
exactly
anti-avoidance of income tax.
Yes. But the motive defence is talking about the purpose of the transfer, and so that's one of the points I will be making, that subsection 1A makes it clear that the Sassoon approach is correct. Right. So I would submit Lord Wilberforce is not, and as my other friend said, he is in fact the majority opinion, because if you find enough people agreed with him for him to be majority, he wasn't making a point about the construction of such an individual, which is the point that Lord Viscount Dillon makes. He wasn't making that point, I think, quite rightly, because it's just an impossible construction of the provision. But what he's saying, I think, is in general terms, that's what the provision is aimed at. I think that's what he says, directed against those persons. And therefore that broad linguistic guide, it supports his conclusion, which is mainly though based on, I would suggest it's quite clear from reading his judgment and all the other judgments, that the fundamental core of this decision is about the unconstitutionality of the position. I would suggest if there had been a provision in the legislation allowing for apportionment and allowing for an appeal, then this would not have been decided in the way it was. In fact, he makes that clear on page 1445. Where is it? He makes it clear when he talks about. It's on page 1444. Under the quote from the Special Commissioners, he says, "It is interesting to compare this passage and what Parliament has not done in the present case with what it has done in another. There is power, as is well known, to apportion."
You said 14?
I'm sorry, 1441.
41.
Sorry, did I give the wrong reference? 1441. It's a passage under the quote. So what it has done another, there is power, as well known, to apportion, there was a surtax, income of closed companies to shareholders or participators. I don't know if any of your lordships remember those provisions, but including persons entitled to secure income or assets applied for their benefit. But here Parliament has expressly conferred the power to apportion, has laid down principles, has defined the period which assessments will be made, has allowed for appeals in a detailed and precise manner. The contrast in this legislation to the present is striking. So that, and also all the comments that are made about the unconstitutionality of this, the position the Revenue are arguing for, makes it clear that that is the core of the decision in Majesty. And Lord Wilberforce himself says that he thinks that on linguistic terms, the decision in Congreve is perfectly supportable. And if it wasn't for the unconstitutionality...
Sorry, where do you get that?
He says that...
He says it's possible, but a less natural meaning of the section.
Yes.
That's page 1443,
He says
letter
that,
B.
yes. Exactly.
Yeah. He
And I think he says...
doesn't quite endorse it.
That rather suggests if matters had been free of authority when Vesti had to be decided, Lord Wilberforce would have preferred his own natural reading.
He might have, but he wouldn't have... I don't think he would have regarded that as sufficient to overrule the previous decision.
No, I was putting to you, suppose Congreve had never been decided
yes.
and Lord Wilberforce looked at it for the first time. If he's saying, I, Lord Wilberforce, think the natural meaning is this, isn't that indicative of that he would
He might
have
have,
viewed it in that way?
it's very difficult to separate these things, I would suggest. Clearly, if you want to come to a particular conclusion, then it's difficult to avoid the saying that one is slightly better than the other. But I take your point, my lord. It's possible that he might have decided the case the other way. But of course, the arguments would have been very different if there had been an apportionment provision in the legislation. Because of course, that in itself might have indicated what was intended. So that would have been quite an important factor the other way. The other thing he said about it was in 1444. He said it was a decision, was a one of interpretation. That interpretation accepted was, as I say, with all respect, a tenable one. So he was. That's in 1444 at the top. And similar comments are made by the other members of the House of Lords. So that is I would suggest the core of the decision. And I think he repeats the point about the language in 1444, just below letter C. The alternative, which is supported by the language, is suppose the section was intended as a limited section, etc. This is repeating really what he said previously. But again, he's talking in terms of it was intended as a limited section. He's again not. This is not a black letter construction of particular provisions, whereas Viscount Dillon did do that in his speech. So this was what we might call an extreme purpose of construction in order to avoid unconstitutionality. What he doesn't say anywhere is precisely how he is construing subsections 1 and 1 and now subsections 1 and 2 of 739. All he does say in the end is it is to be interpreted, this is paragraph 1446, as applying only when the person sought to be charged made or maybe was associated with the transfer.
I'm sorry, what page was that?
1446, letter E. That's his conclusion. Congreve should be departed from on its principal ratio. Section interpreted as applying only where.
Yeah.
But that's perhaps I would suggest an example of a broad interpretation of the provision, that there is this limitation which isn't spelt out in the provision, which must be there in order for the provision to be constitutional, I suppose. Whereas Pike and Dillon took a more black letter approach on page 1451. Where he says the interpretation of such an individual, he says that the meaning does not appear to have been debated in the House.
Sorry, where are you on the page?
I'm sorry, it's 1451, at the very top of the page. Lord Justice Cohen.
Oh, yes, thank you.
Yeah. A possible meaning appears to me an individual or a resident who has sought to avoid liability to income tax by means of a transfer of assets abroad. If that was their meaning, then the scope of 412 is limited to the individual or the resident who has sought to avoid liability to income tax by means of a transfer of assets abroad. That's picking up the words of subsection 1, which are setting out the purpose of the provision, and somehow applying them to the individual. That is, I would suggest, a minority view, and it can't be right on any terms, because we haven't looked at section 741 yet, but section 739 can apply even if the transferor, as regards the original transfer, had no intention to avoid any tax, no purpose. So it's not a condition of section 739 applying that the transferor should have sought to avoid liability to either income tax or indeed any tax. And if it was, it would be placing a condition on 739, which would again rather emasculate the provision. It's quite clear, I'm going to take you to 741 later, it's quite clear that the provision can apply if the purpose of an associated operation subsequent to the transfer is to avoid tax, even if the original transfer was not, had no purpose of avoiding tax. And this is quite a common situation, afraid, those of us who practice in this area. Transfers may well have been made years ago by individuals when they had no connection with the UK whatsoever, creating a structure, an offshore structure. Then decades later, the individual might come to the UK and become resident here. And questions apply about the application of section 739 or now 720. And one has to look not just at the transfer, but you have to look at subsequent associated operations which were carried out, may be carried out by companies in the group where the transfer was affected for all sorts of reasons. And you have to ask whether they were affected. These would be associated operations with the original transfer because they would be affecting the property that was transferred. And you would ask the question whether avoiding UK tax was a purpose of those transactions.
And are you going to show us how that works? You said it's all perfectly clear.
Yeah.
I'm afraid that bit isn't.
I'll take the simple one, but I'm just making the point now, I'm trailing it, that this is not a condition. And I don't think, to be fair, that the taxpayer was arguing for this. I think this is something that perhaps Michael and Dillon came up with himself.
Although, I see Lord Edmund Davis, you may be going to come on to his speech.
He also, yes.
He adopts a similar approach, and he cites a passage from Lord Green in the Lord Howard Walden case back in the 1940s, which seems to suggest that was the meaning given to it by the Court of Appeal at that time. This is the taxpayer who plays with fire.
Yes.
Shouldn't complain of burnt fingers passage.
Yes.
Page 1459.
Yes, well, the point that was being made there in the passage from the Court of Appeal was that there was no connection between the benefit that you might get and the charge.
Yes.
That was the point that was being made.
Yes, but you'll see the passages that Lord Emmon Davies has highlighted, the indented passage, and then and again the passage between E and F, and so it's clear that the Master of the Rolls had taken the view that the section was aimed at transferors whose purpose was tax avoidance, and
that's I'm sure that's true as a generality.
Yeah.
But the point I'm making is it can't be a condition for the application of Section 739.
No, I appreciate it's not fine. Your position.
Yeah, it's fine to say, as they say, I think later on under that passage, he is the person against whom the deterrent action of the section is directed. There's no doubt about that. But it doesn't follow from that is a condition of Section 739 applying, if that is what is being suggested. And I think that's what Viscount Dillon and Lord Emmon Davies seem to be saying, that the reason that they say that you can limit it to the transferor is because it's that person who was seeking to avoid tax that the provision is aimed at. But the problem with that is that person might not be seeking to avoid tax. Certainly not income tax. Certainly not any tax, perhaps. So I would suggest that the true reasoning, the majority reasoning, is that of Lord Wilberforce, who's taking a broader approach to the interpretation. He's not fastening on any particular words in subsection 1, but he's just looking at the broad purpose of the provision. And if you that method of interpretation is perfectly legitimate. To say that in broad terms it's aimed at transferors and in broad terms it's aimed at those who are seeking to avoid tax is perfectly consistent with the provisions. And therefore, because of that, you deduce from that broad purpose of the provisions that there has to be a transferor, using that shorthand term.
Right, and you say, well, we don't have to worry about that now because there's Section 744, which allows for apportionment, and if that had been there, then maybe Lord Wilberforce would have come to a different view.
I say that doesn't really matter, but what I do say is that because 744 is there, and perhaps subsection 1A, which again appears to contradict some of this reasoning, the provisions are materially different from the ones which are in Majesty. So I don't say that concludes the case in our favour.
What conclusion do you invite us to draw from that? In particular, are you inviting us to draw the conclusion that now there is no need for the person to be a transferor at all, in which case we don't have to worry about multiple transferors and all those difficult questions, or do you not go that far? That's
my primary submission is that you don't Majesty is not directly relevant to the construction of the legislation as it stands today.
I understand that.
And you do have to construe it today and decide what relationship there is. And I say that I think there is a way of steering between all the problems that your lordships have stated. But if you conclude that trying to impose some implied limitation of this sort is impossible, then the fallback provision would surely be to say that it's not necessary, because there's no necessity for it any longer. But that would only be because you conclude that as a matter of construction you cannot find any legitimate way of construing the legislation as it stands in order to impose a condition. And that's what we've been debating this morning, whether you can actually do that. I think all I'm pointing out is that if you throw up your hands at the end of it and say, well, it's impossible, there's no principled way of doing this, one answer might be, well, you don't need to do it.
Right, so if we feel we're faced with a choice between saying, okay, it's the actual transferor, or in a company it's the controlling shareholder has more than 51%, you say, because that is then makes it too easy to avoid, you're better to just say, under the new legislation, Vesti was wrong, and Vesti doesn't apply, and there's no need for them to be the transferor at all.
I wouldn't put it that way, my lady. The way I would put it is, if you conclude that you can correctly, legitimately construe the legislation as only applying to those who directly transfer, or an individual who controls the company and procures it, if you feel that you can do that, looking at the legislation and bearing in mind the purpose of the legislation and the fact that it's anti-avoidance, then that's fine. I'm not suggesting that you should then, because of that, but if you conclude that cannot be the correct construction because it's too narrow, and that a wider construction is just not possible because in principle you can't find a way of steering between, of stating a principle that would limit it, then that may be a circumstance where you might say, well, why are we torturing ourselves to find an implied limitation when we don't have to, if it's not possible to do? That's all I'm saying. So you don't get to the stage of saying, well, we can't find, there ought to be a limitation, but we can't actually conceive what it is, and therefore we'll simply say it has to be the transferor directly. I think that would be the wrong approach I would submit to take.
Can I just check with you, for the purposes of the assessment under section 739, subsection 2, I take it that the power to enjoy income of SJG is taken to be held by the taxpayers by reason of their shareholdings in SJG.
It is, yes. My lady was asking about that. We haven't managed to. Would it be helpful if we went through some more of the legislation, perhaps, and we come to that at this point? Sorry, just to finish off Vesti, can I just draw attention to what Lord Keith said?
Yep.
On page 1465. This is beginning just above letter F. He says, in the result, transfer of assets by the taxpayer's father were held to involve her liability under the section. The House also accepted an argument that in any event, certain transfers had been organised or brought about by the taxpayer herself. By this ground, although capable of supporting the correctness of the actual decision on liability to tax. So that's what I said about there being approval, if you like, of the alternative ratio was plainly a subsidiary one. And then he goes on to say that the principal ground was erroneous. And he repeats this, who sought to avoid liability to income tax by means of transfers. The other point is subsection 8A, which some of the House of Lords, although I don't think Lord Wilberforce thought was a point in favour of that construction. And what we said is, well, no, because you can figure lots of cases where, forgetting who the transferor is, the person who has power to enjoy might be, for instance, a husband who is non-resident, whereas the wife is resident. And or it might be non-domiciled, which is another situation where, although you're not completely exempt from tax, the remittance basis applies.
Is this the spousal extension?
This is a spousal extension.
Does that exist in the current law, or the law
Yes.
that we're dealing with?
Yes,
Where
it's
is that found now?
It's always been there. Yes.
Where
Still
is it
exists.
now?
Sorry?
Where is it now?
Do you mean by that in the 2007 Act?
In the legislation which we're applying?
All right. Thank you. It's 742, which is one of the interpretive provisions, subsection 9. It has continued. I'm very grateful to my learned friend for having that at his fingertips. It has continued throughout. It's an obvious, necessary part of the anti-avoidance.
Sorry, which bit of section 742?
742, subsection 9.
9, sorry.
1060 in the electronic bundle.
Yeah.
My other friend's answer to that appeared to be, well, in the kind of example we give, the motive defence would inevitably apply. In my submission, that's clearly not the case. A transfer by one individual, one spouse, to a non-resident company, where the shareholding is held by the other spouse, one can imagine a clearer case of tax avoidance, assuming that was the purpose, so most likely to be the purpose. So it's really hard to see how that's an answer to the point. It cannot be in every case of that the motive defence would apply. Certainly, we would suggest that can't be right. The point we're making is that you need the extension in relation to power to enjoy just as much in relation to transferors. So it's not a good point to say that would be OTOs if Congreve was right. Again, I think that was very much a subsidiary point, the kind of point that you wouldn't be relying on if it wasn't for the major unconstitutionality issue investing. Can I then show you what some short passages from Magukian, which is the case which I think is in the supplementary bundle?
Yes.
This is a strange case in many ways. The taxpayer entered into a scheme which...
Entered into a?
Sorry, it's a strange case. The taxpayer entered into a scheme selling a right to a dividend in an attempt to turn it into capital from income. The problem was that there already was an anti-avoidance provision, which is section 470, which actually would have negated this plan. Unfortunately, due to, I think, obfuscations by the taxpayer's representative over many years, by the time the revenue came to make their assessments, they didn't realise all the facts were, and they made assessments under section 478. Not under 470. And then the time for making assessments under 470 ran out. And one of the arguments by the taxpayer was, well, there was no tax avoidance here because the scheme didn't work in the first place.
No tax avoidance because what, sorry?
The scheme didn't work in the first place. I think it's admitted to be a highly unmeritorious argument.
didn't work because of section 470? Or?
Yes, because of section 470. So you can see that on page 3248.
We'll have to do some mental arithmetic.
Sorry,
We can see the top,
997 internal,
I'm sorry, yeah.
top right hand, what the numbers.
page 7 of the...
3248 at letter
At letter H.
H.
Mr. Nugent submitted, since the dividend would not in any event would in any event be taxable on the 470, section 478 does not apply. He based his submission on the words in the preamble to section 478 for the purpose of preventing the avoiding by individuals, ordinary resident United Kingdom, of liable to income tax. He submitted that section 478 does not apply unless tax has in fact been avoided. In my judgment, there's no warrant for the submission. The words quoted refer not to the intention of the transferor of the assets or to the effect of such transfer, but to the intention of Parliament in enacting the section. That parliamentary intention is certainly relevant in construing the section, but the words in subsection 1 make it clear that the actual avoidance of tax is not a precondition to the application of the section. That's it, and then he goes on. And Lord Clyde made a similar point on page 1005 internally, if that helps, page 3256. He says, my lords, at the bottom of 3256, the assessment of tax was made under section 478. The opening few lines of that section set out the purpose to be served by the enactment. That purpose is the prevention of avoidance by individuals, ordinarily resident in the United Kingdom, of liability to income tax by means of certain kinds of transactions. It is not required that the transaction should itself be carried out with that purpose. The statute is simply expressing the purpose of the section, not of the substance of the transaction.
I'm so sorry, where on that page were you reading?
Sorry, it begins right at the bottom of 3256, Lord Clyde, and then it goes on to the top of 3257.
Yes, I see, thank you.
Now, the odd thing is, when we come to look at Willoughby now, you'll see that Lord Nolan says precisely the opposite to this. And rather amusingly, Lord Clyde agrees with him. So I don't know where that gets you. Willoughby
This is the authority that you rely on to say that what we've been referring to as the preamble doesn't limit the scope of the provision.
Exactly, yes. What they're saying here is that it's stating and if you read the provision, you can see that's the case. It's stating the purpose of Parliament, purpose of the legislation. It's not telling you anything about the purpose of a particular transferor in any particular factual situation. I think you can draw that from the words of it itself, but I just thought I'd show you where the House of Lords made that point. But what was then said in Willoughby was this. And this is page 1384, Lord Nolan. At the bottom, just below letter G, he says the crucial words, as it seems to me, are those in subsection 1, which state that the section is to have effect for the purpose of preventing the avoiding by individuals ordinarily resident in the United Kingdom of liability to income tax by means of transfers of assets, coupled with the identification in subsection 2 of such an individual as the subject of liability. What can the word such an individual refer to, say, for an individual of the kind described in subsection 1? That is, an individual ordinarily resident in the United Kingdom seeking to avoid liability by means of transfers of assets. So I would submit, and I think he's getting this from Vesty. He goes on to say, although the point was not determined in Vesty, the view they are taking that the individual to be charged must be the individual who made the transfer seems to me to lead inevitably to the conclusion that the individual concerned must be the one type of transferor with which the section is concerned, and that is a transferor ordinarily resident in the United Kingdom. At the risk of seeming overconfident in expressing an opinion about language which has been construed in diametrically opposite senses by your Lordship's House in the past, I would say in the light of Majesty that this is the natural and plain meaning of the words used. This was, in fact, July 1977.
June. That was the passage that I had in mind when debating what Lord Wilberforce in Majesty said was the natural meaning of the words used. I mean, is this not Lord Nolan essentially agreeing with what Lord Wilberforce said was the natural meaning of the words used?
I think he's, I would submit, in fact, he's agreeing more specifically with what Viscount Dillon said and the others about the specific limitation.
Yeah, there may not have been much, I'm not sure there's much disagreement about this in Majesty, because we have Lord Wilberforce saying it's a natural meaning, and then Lord Dillon, with whom Lord Salmon agrees, and then Lord Dillon, Lord Edmund Davies and Lord Keith all take the view that the section refers to an individual who had the intention of tax avoidance.
Yes, it's saying that it applies to an individual whose intention was tax avoidance, where I think I would submit is not an accurate statement of the provision.
I appreciate it's not your view, but
it's not my view, and it's not
or your submission anyway.
Not,
but it's the,
well, I think on any view it's not correct. I don't think there's any construction of the legislation which would lead that to be literally.
Nonetheless, it's a construction that appealed to a number of our predecessors.
It did, although, as I've just pointed out, about a month earlier, the House of Lords, at least two of the House of Lords, had stated pretty much diametrically the opposite as being the significance of the preamble. So I'm not sure it's really that clear. But in any event, the problems that would have caused if that was right led to subsection 1A being introduced. And that, can we just turn up Authorities Bundle, page 1841. 1841. This is the amendment. I've just introduced this because look at this because it has subsection 2, which is the application of the provision, which I think is significant as well. So this is when it was introduced in 1981 as 1A. Nothing in subsection 1 above shall be taken to imply that the provision of subsections 2 and 3 below apply only if the individual was ordinary resident at the time when the transfer was made. Well, that was directly the decision in Willoughby. Or the avoiding of liability to income tax is the purpose or one of the purposes for which the transfer was effected. So what that is saying is that you cannot imply from subsection 1, the preamble, that the avoiding of liability to income tax is the purpose or one of the purposes for which the transfer was effected. That the provisions would only apply if that was the case.
So you say the debate in prior case law on these matters is swept aside?
It's settled by this provision, yes.
Oh, it ceases to be relevant?
Yes, exactly.
I can see subparagraph A required in order to reverse Willoughby. Was B required in order to reverse Willoughby, or was it making some different point?
Well, I think it was the concern from what we just read in Willoughby that it might be interpreted as meaning that there was a requirement for Section 739 to apply, that the purpose of avoiding liability to income tax was one of the purposes for which the transfer was effected. That would be an additional...
So it's saying that insofar as there's a contest between Magoukian and Willoughby, Magoukian is right.
Exactly. That's what this... And interestingly, it's the way the amendment is carried out, the reversal, is simply by, as I said, I think yesterday, by reversing the reasoning. Because the reasoning was that you can imply from subsection 1 these various things. And what this is saying is you can't imply that from subsection 1. That was precisely the reasoning of Lord Nolan, what we just looked at in Willoughby. But this, in our submission, this also answers the section 741 question. Because the taxpayer's case has to be that avoiding liability to income tax must be the purpose, or one of the purposes for which the transfer is effected. Otherwise, the provisions can't apply. If they construe
I can see that in effect answers the first limit of the section 741 question. It doesn't answer the second, does it?
Well, it does.
Identified a commercial transaction. Because it's a different test there.
Only if, but it has to be a purpose. Avoiding liability to income tax would still have to be, it would have to be the purpose of the provision under the second limit. It has to be the purpose. Otherwise, the second limit wouldn't apply. If it wasn't,
but this provision is saying subsections 2 and 3 shall apply only if the avoiding of liability to income tax is the purpose or one of the purposes. So in order to make them apply, you just need it to be one of the purposes. And then
under the first limit, that would be right. Under the second limit, it would have to be the purpose, the main purpose.
No, but you only get in section 741 and the motive defence if you're within section 739 in the first place. So this is just governing the operation of section 739, whether you're in section 739 in the first place.
Well, okay. I put the argument perhaps slightly differently, which is, well, I'll come to that when I come to the question of taxation.
Okay.
But I would suggest that if it really was the case that 741 was limited to income tax, then providing for this would be something of a legislative joke, because it would not be, as if your lordship is right, it would not be affecting the fact that it was limited to income tax. So it would have said you can't imply anything from these provisions. I mean, can I put it this way? My learned friend's argument, and I'll take you to this yesterday, was precisely that. The reason that you interpret taxation as income tax is because of the purpose of the provision demonstrated by subsection 1.
Yeah.
So that is exactly the argument, and that's not an argument. That's an argument that's not open to you because of subsection 1AB.
Well, I don't see that. Well, at the moment, I don't see that at all. 1AB is dealing with the purpose of the purpose for which the transfer was effected. Fine. So, it isn't necessary for the operation of the section that the purpose for which the transfer was effected was the avoidance of income tax. Nevertheless, the purpose of 739 is to prevent avoidance of income tax. It's not focusing. The point is, a transfer is one thing. It happens at a particular point in time in particular circumstances. But the provision is addressing income that arises subsequently and the attribution of that income to people for the purposes of income tax.
But the operation of, I mean, that is the application of the provisions of subsection 2 and subsection 3. To say that they only, well, if the taxpayer was right, they would only apply if the purpose of the transfer was, or associated operations, I accept, to avoid income tax. So,
I mean, the effect of a transfer could have the effect of income tax being avoided without that having been specifically the purpose of it.
Oh, yes, yeah. But this is talking about the purpose.
Yes, I know 1AB is dealing with the purpose of the transfer.
Yes.
Subsection 1 isn't dealing with the purpose of the transfer. It's dealing with the purpose of the... Yeah.
Yes, I understand that. But what this is saying is that you can't deduce from subsection 1. Nothing in that section is taken to imply that the provisions only apply, the charging provisions, which is subsection 2 and 3, only apply if the avoiding of liability to income tax is the purpose or one of the purposes for which the transfer was effected. Now, if you say at the same time, okay, section 741 can only be failed if you had a purpose of avoiding income tax, then you are contradicting this provision, because you are saying it is the operation of subsections 2 and 3 are limited. They only apply.
I'm having difficulty with this argument. I'm not sure that I'm following it.
Yeah, I'm not.
The effect of subsection 1A is to make it clear that when you're looking at the transfer, you don't read in from subsection 1 that the transfer itself has to be with the purpose of avoiding tax. So the effect of the transfer will be to avoid tax, and that's going to be good enough to bring yourself within subsection 1, precisely because 1A(b) is saying you don't imply from what is written in subsection 1 that the purpose of the transfer has to be to avoid tax. So
income tax.
Income
Yes.
tax.
It may have to be to avoid tax.
Well, all right.
Yeah.
Except subsection 1 talks about avoiding income tax as well.
The point about this is whether it's limiting it to avoiding income tax, or it can be a wider tax. Taxation would be wider. What this is saying is you can't draw the conclusion, implication from subsection 1 that the provisions only apply if income tax avoidance is the purpose.
Well, that was the whole... Well, I mean, in the first place, subsection 1 tells us that's the purpose of this legislation. Secondly, 1A is the mischief that gave rise to 1A we've just seen is the view taken in Willoughby that the avoidance of income tax had to be the purpose of the transfer.
Yes.
And they weren't concerned with corporation tax or inheritance tax or betting duty.
Yes, but it follows from that. If the avoiding of income tax has to be the purpose for it to apply, then it wouldn't matter whether you were avoiding betting duty or corporation tax or inheritance tax. You'd have to be avoiding income tax, have a purpose of avoiding income tax before the provision could apply.
Yeah.
Which means essentially the purpose test is limited to income tax.
Well, that was the reading in... But
Yes.
Willoughby thought the purpose of the transfer had to be, the purpose of the individual who effected
Yes.
the transfer had to be the avoidance of income tax.
Yes. Yeah. Yeah.
My understanding was, and I thought you were emphasising to us, that Magookian, the House of Lords had reached, in effect, the opposite conclusion. They'd said that the purpose of avoiding tax does not have to be the purpose of the transfer.
Yeah.
The reference in the preamble to avoiding income tax is as has been put by my lords, the purpose of the charge, not the purpose of the transfer.
Well, they did say that, but then in Willoughby,
yes,
unanimously they said the opposite. Yes.
But doesn't that emphasise that the point of subsection 1 capital AB is, as I think my lady said, to show that the interpretation in Magookian is correct, that you're not looking, you don't imply from subsection 1 that the purpose of the transfer has to be to avoid income tax. In other words, insofar as there's between Willoughby and Magookian is right.
Yes.
Parliament says so.
But what I'm saying is that you cannot equally say when we're interpreting the motive defence we can look at the purpose in subsection 1.
Well, that's where I jumped in and said I didn't follow.
That's what I'm
I see no logic there.
I'm going to say that's part of the argument on that.
Because I mean, as I understand it, this provision, and now provisions, has always operated on the basis that certain things are caught by the charge, and the effect of Magoukian and now subsection 1A is to make the charge wider. So more things are brought in. There were potential ways to cut down the ambit of the charge, but they've been knocked out now because the transfer, you don't say the purpose of the transfer has to be to avoid income tax. It's just the effect.
I'm not sure it was ever, in fact, administered.
All right, well, whatever. To make my point, you have a charge which is of a certain width, and the motive defence was always intended to be, it started off as a proviso to the charge, and now it's a separate provision, to offer a defence not predicated on marrying up with the basis for the charge, but having its own independent basis on which you could get out of the charge. So you're presumptively within the charge, but if you can bring yourself within the motive defence, you get out of the charge. Not because the charge doesn't apply to you, it does, but because you're within the scope of the motive.
Can we look at section 741?
Yeah.
Because it does actually say that it shall not apply. 1046 in the...
Yeah, but it only...
Section 739 shall not apply.
Sorry, yeah. But it only needs to say that because section 739 will otherwise apply.
Would otherwise apply, yes, exactly. But it is saying that section 739 shall not apply.
All right.
And what subsection 1E is saying is that nothing in subsection 1 should it imply that the provisions only apply if avoiding liability income tax is the purpose of one of the purposes.
Because purpose, how you get out of the charge, relying on your purpose, one or main, is by looking at how section 741 applies, not by looking at how section 739 applies.
Yeah.
Okay, but my point is that if my other friend is right, then the effect would be that section 739 would not apply unless the avoiding of liability income tax was the purpose or one of the purposes. It would not apply because the effect of the motive defence, as construed in that way, would be these would be the only circumstances in which the provisions would apply. To say that in subsection 1A and then to say, well, in fact, the effect is achieved by looking at 741 would be rather peculiar.
It puts the onus on the taxpayer to establish it.
Yeah.
Prima facie, the charge applies without regard to the purpose. But the taxpayer has the burden of showing that it was a bona fide commercial transaction and it wasn't designed for the purpose of avoiding liability to taxation.
If it was a condition in subsection, if it was a condition, another condition, it would still be for the taxpayer to show that it applied. The burden's always on the taxpayer to show these things. It wouldn't be for the revenue to show that it didn't.
Right, I'll tell you how I'm reading these provisions together at the moment. You can tell me I'm wrong.
No difference.
Section 739(1) it posed certain difficulties of interpretation which have been explored in the cases. Yeah. A particular issue arose between the Magoukian interpretation and the Willoughby interpretation, which that difference was dependent upon whether one read in from subsection 1 that it was a condition for the charge to tax that the transfer have a particular purpose, specifically to avoid income tax. The Magoukian view was, no, it didn't, that the preamble was just looking at the purpose of the charge, not the purpose of the transfer as a condition for application of the charge. Willoughby suggested differently. Parliament, in subsection 1A, has opted for the Magoukian view. So it has legislated, in line with Magoukian, that the purpose of avoiding income tax is not a condition for application of the charge. In other words, the charge is based on the effect of a transfer having happened and having the effect of avoidance of income tax, even though it didn't have that purpose when the person entered into the transfer. So that sets the width of the charge. When one comes on to the defence...
So it doesn't have to be effective of avoiding income tax. That's not part of the conditions of the charge.
All right, okay.
Yeah.
But the important point of what I'm trying to put to you is that the purpose of avoiding income tax is not a condition for the application of the charge so far as the transfer is concerned. In other words, you look at the transfer, you do not have to say, and was this transfer entered into for the purpose of avoiding income tax before you applied the charge? You're happy with that?
Yeah.
When one turns to section 741, you're looking at something which is presumptively within the scope of the charge, but a defence is given to the taxpayer where the taxpayer can point to the purpose of the charge, and if he is able to show that the charge had...
Purpose of the transfer.
Purpose of the transfer, forgive me as I'm misleading myself. The purpose of the transfer, the taxpayer, if he can show that the transfer had particular purposes or did not have particular purposes, is given the possibility of a defence to what would otherwise be the charge under section 739. So, on my understanding, the effect of subsection 1A is to make clear that it is not a condition for application of the charged tax that the transfer should have been conducted with this particular purpose. But section 741 gives the scope for a defence to the taxpayer by pointing to the purpose of the transfer and saying, for the purposes of the defence, can show that the transfer had certain qualities as regards its purpose. So one says, the application of the charge, I'm putting this crudely, but forget about purpose of the transfer. The second is, for the purposes of this defence, it's all about the purpose of the transfer, and this is what you have to show.
Yeah, well, I agree with you, except I would suggest that 1A is wider than you say, because it's not simply stating, as I said before, it's not simply stating that something was wrong in a particular case. It's actually telling you that you cannot draw a conclusion from...
Yes, I agree with that for the purposes of this debate, but that's just for the purposes of section 739. You were making to us the submission that section 739(1)A means that the taxpayer's proposed interpretation of section 741 cannot be right. And what I'm putting to you is that these are ships that pass in the night. Subsection 1A is addressing the ambit of the charge, saying forget about purpose so far as the ambit of the charge is concerned. Section 741 is addressing a defence and is saying for the defence the purpose of the transfer, the purpose of the transfer is what's important. So if you want the defence, you do have to look at it.
Well, first of all, I'd say it's not just on its terms applying to the ambit of the charge, as your Lordship says. It's talking about whether the provisions apply only if. So it's the application of the provisions that it's dealing with. And what I'm saying about it is not that this necessarily concludes the question on taxation, but what I do say is that it means that the taxpayers cannot rely on subsection 1 as supporting their argument in relation to say, look at subsection 1 and therefore it must be income tax, limited to income tax in 741. That's my submission about this. I'm just saying what this is saying is in relation to the application, whether subsections 2 and 3 apply only if these things happen, you can't look at subsection 1 and deduce something from it. That's what you get from it. Otherwise, you would be saying, well, in relation to it's not a condition, but in fact it is a condition because it comes into section 741.
So there's an important difference between 741 and 739, which I think you're overlooking, which is that when you're looking at decisions about 741, the burden is on the individual to show to the satisfaction of the board about what the purpose is, and then the jurisdiction of the special commissioners on any appeal should include a jurisdiction to review any relevant decision, which I take to mean that if the individual is challenging the application of 741, it's a different standard of review that the tribunal...
It's a full appeal. It's always been agreed. That's what happened in this case. It's a full de novo appeal to the special commissioners. That was the first tribunal. They decide it from scratch.
It's not a review,
it's not
despite the wording of the provision.
No, it's a complete... as in the present case, they didn't look at the revenue decision and review it. They looked at all the facts and came to their own conclusion. That's what this provision is intended to...
I should indicate that at the moment I don't see, I don't understand your argument that the taxpayer cannot look at the scope of the charge in subsection 1 of section 739 when construing section 741, because on your approach, Parliament has said this is a charge in respect of the avoidance of income tax, but 741 has the effect that it's a charge in respect of the avoidance of tax, generally.
We're going to have to tear ourselves away from this for a short time. Before we do adjourn, I'm a little concerned about time, and it may be that Mr. McGurk is also concerned. You've obviously got a bit more to say yourself, Mr. Ewart. I'm wondering about how to spend the afternoon. Reply time, you're going to need some time. Would you need more than half an hour?
We had anticipated, my Lord, half an hour. When you very kindly extended, we said possibly more time, but we lost that yesterday. It's about half an hour. That's what we were working on.
That would allow the revenue another hour, but if you don't feel you're going to need that time, then can I leave it as a matter of discussion between counsel?
Yes, I think it would leave the revenue another hour and a half, wouldn't it?
An hour and a half. Yes, you're
an hour and a half, and then half an hour.
Right, an hour and a half.
There is
and you might not need as long as that, Mr. Ewart.
I think Mr. McGurk actually probably wants the whole of that, actually, I suspect, and a bit more. Should we discuss it?
I don't want to have to lay down the law unless I need to. If counsel can discuss the matter and reach an agreement about it, that would be helpful.
It may depend on your lordships to some extent. I think.
Well, if it helps you, I'm not sure we need as much help on the EU point as we do on the domestic law point.
I'm not sure about that.
Okay.